Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
And I'm Aaron Chen.
Welcome to Hull on Estates. You're listening to episode number. Do we know what the episode number is? It is episode number 728. Can you believe it? That seems like a very high number.
That is a very high number, Doreen.
We must have been doing this for years. We've been doing this since I first started practicing as a first year, so it's been like well over it, at least over 10 years now. So anyways, having done this for so long, perhaps I should be better and smoother at it. Today
You're a
we're going to
professional
be
podcaster, Doreen.
That's right. Today we're going to be discussing a case called Klemensiewicz and Klemens. It's a case from the Ontario Superior Court of Justice. It came out actually fairly recently, August 8th, 2025. This was a case that you brought to me, Aaron, because it has, I think, a very straightforward and like human story behind the claim, but also has like an interesting like limitation argument and decision associated with it. Do you want to tell us a little bit about why you chose this case and what this case is about?
Sure. So I'll start by saying that this is a great case to use as sort of a springboard for a refresher discussion about the applicability of limitation periods to equitable trust claims over property. And having said that, the facts of this case are that the applicant husband was in the process of getting divorced from his wife in 2010. They had 4 children together. 2 of them lived with the wife, and the other 2, being the respondents, lived with the applicant husband. The applicant learned from the respondents that there was a larger home in the neighborhood that would accommodate them all. The respondents couldn't afford this house, and so the applicant decided to offer some help to buy the home. And so the applicant gave funds to the respondents, and the respondents purchased this new home. As part of that transaction, they obtained a general form from the bank that documented it. It was signed by the applicant and respondents on July 21st, 2011. The letter was entitled as a, quote, gift letter, and the essential terms are as follows. Quote, the undersigned, being the applicant, hereby confirms that a financial gift in the amount of $525,000 is being provided to the respondents. The person receiving the gift and the person giving the gift certify the following. The funds are a genuine gift from the donor and are non-repayable. The applicant also never made any request for repayment of that amount. And he also admitted that he knew he was never on title within a few months, but he did nothing to correct that. He admitted to paying rent, and he also wrote rent checks to the respondents. And so in the circumstances, the court held that their proceeding was statute barred by Section 4 of the Real Property Limitations Act, which imposes a 10-year limitation on any action to recover land or rent from the time the action first accrued. Court held that this includes constructive and resulting trusts in respect of land. And so in the circumstances, the court found that the transaction took place in 2011, and the transaction included everything from conveying the money to the respondents, the gift letter, and the applicant's realization that he was not on title.
All right. So here I'm actually going to take like a slightly different view on this case because like to me, the case and when you read like the reasoning, it really is all about at the end of the day, the judge did decide this case on its merits. It didn't just dismiss the case based on a limitations argument that because it was statute barred under the Real Property Limitations Act, he's not going to like get into the merits because it's almost like the reasons were flipped. He really like looked at what the applicant was asking for, right? Like the relief sought, looked at really like the history amongst like the parties, and then it looked at like all the evidence that like the applicant put forward as well as the respondents, and at the end of the day he decided like no, this was really a gift. um and I think this was like a fairly easy decision to make, especially because of like the gift letter that you just read out to us, right? Like there was sort of like nothing even remotely like iffy about the language. It was just such plain language. And the court actually went and really like looked at how there's just even like layers of evidence that like contradict the applicant's now claims that the money wasn't just like freely given without any consideration. And then at the end, they're like, okay, since the respondents also like raised the limitations defense, I'm also going to decide their limitations of defense. So, like overall victory for like the respondents here. But I think, you know, this type of case like comes up a lot, right? Like how people come to buy their houses, as well as like how people come to even be able to like afford their houses like over time, especially like when families go through like difficult financial circumstances, divorces, etc., and then when parents come in to help, right? In this case, it's like, when he said at the beginning, I think it's like that human story of like, there's a divorce. Mom and dad is divorced. There's 4 kids. 2 kids signed it with mom, 2 kids signed it with dad. Dad moves in with the 2 kids he's like on side with, but it was just like too much for everybody to live in the small house. So like then, hey, let's get a bigger house. We can all live there. And guess what? I'm the dad. I have the money. I have $500,000 to give. Now, the word give is like kind of neutral, right? Like you can give something away for free, which is like a gift, or you can give it away in exchange for something back, which is where there's like that consideration. Or you can give it as a loan and you expect to be repaid at some later point, and then that's a loan. Um, So for, the dad in this case, it seemed like over time, especially when the money was given and the house was purchased, there's sort of like no question as to whether or not it was a gift in the first place. And the judge, like, I think unfortunately did hammer him quite hard on that, because it seems like as you read the decision on, it's like since um he's gone older, he is no longer having such a great relationship with those 2 kids he bought the house with, as like the other 2 kids that he didn't like. When he first got divorced, it seemed like the teams have switched over time, and now he wants that $500,000 back. Well, you are stuck with everything that like you did at the time as well in the past, which is, another good way to bring back those limitation arguments, right? Like you can't just sort of like let things go for so long and then do nothing about it. And then like over 10 years later, then come back and say like, no, 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 that's not what that was. That's not a zebra at all. There were no stripes there. This is not a gift. I like I deserve like my interest in land, or at least I should get a loan and it should be like repaid back to me. Here I actually thought like, when it's such a simple story, you can almost like use it like a law school example or a CPD example as to like, well, what should people be doing when they're getting money from a parent to buy a home? How should they document how they came to receive this money? Well, it seems like, the couple here in this case, the respondents, like they did everything. At first, they thought it was a loan. So the wife actually like printed out a loan agreement from the internet, and her father-in-law didn't sign it. Then when it came time to actually do the transaction at the bank is like, okay, well, I'm hearing this is a gift. Let's document it. And again, like it was such plain language. The funds are a genuine gift from the donors and are non-repayable. Right? Like it's so hard, aside from like maybe having more to say about like dad's capacity at the time when he signed it, or like even like undue influence, vulnerability issues, but without having any of that there, and this man, it's funny, like the judge even commented that like from his family law proceedings, like he definitely had well enough money to make this gift to his kids, and that was part of like why he didn't so much as believe that it was a loan. So like all of that could end up like stacking against you. Now, the issue of time, like Aaron, do you want to maybe unpack that a bit?
Yeah, sure. So with respect to the issue of time, so here what happened was that it was a straightforward application, according to the court, of Section 4 of the Real Property Limitations Act. And so just to paraphrase from the act, it imposes this 10-year limitation on any action to recover land or rent from the time the action first accrued. And so in that case, it was very clear to the court that they weren't trying to advance some kind of an equitable trust claim against the estate. It wasn't in relation to any of the estate assets. This was just a straightforward case of the respondents simply claiming a constructive trust or a resulting trust over this home, full stop. And so the 10-year limitation period obviously applied here.
Yeah, and so and again, I think this is where I would say like be careful with this case and the way it decided the limitations issue. I think that the decision has already like, decision was made on its merits, right? So there's either way, in time, out of time, this applicant would not have like succeeded. And ultimately, this applicant ended up having their day in court anyways, because it was like all decided at the same time. Like this wasn't like, a first motion to determine the limitations argument before you determine the merits. So either way, like it's decided. This was a gift. He's not getting any of this money back, and he's not getting any interest in land back. What I would say about how the Real Properties Limitations Act and its emphasis on just Section 4, I want to be careful in just sort of like highlighting a recent decision of the Supreme Court of Canada on the Real Properties Limitations Act that was actually released just this past Friday. It was a decision about our Ontario Act, our Ontario Real Property Limitations Act, and how it applies to adverse possession claims in this province, and in particular, as for possession claims in the context of municipal lands. All of this is very specific, right? Like I just said, specific statute, municipal parklands, adverse possession. That has nothing to do with the case that we just talked about, but it's still important to sort of like look at some of these like Supreme Court of Canada decisions about these very like technical acts that are very like at the end of the day, like very difficult to read and understand, and still get pointers from it, because the decision starts to talk about how Section 4 of the Real Property Limitations Act provides for a 10-year limitation period within which a title holder must bring an action for the recovery of land. So that's the part that you talked about, and that's the part that decision talks about. Then it goes on to say, and that was just section paragraph 32 of this Kozicki versus Toronto decision. Then it goes on to say, like a couple paragraphs down at paragraph 34, Section 5.1 of the Real Property Limitations Act further clarifies that the 10-year limitation period governing the right of recovery begins to run at the time of dispossession. Now, that obviously means something like very specific in the context of adverse possession, but I bring up Section 5.1 because limitation statutes should never be read in a vacuum. The whole statute should always be like considered. And I think anytime you have a limitations argument to make or to defend, you should look at like the whole statute, see what applies, and then take the additional step to look at like additional statutes, other limitation statutes. So like beyond the Real Properties Limitations Act, there's one in the Trustees Act. There's obviously like the Limitations Act 2002, which also like has a limitation period for the recovery of monies that have been loaned. All of this like interacts together. And like, as lawyers, we all like these like bright line rules, or like, what's the top line from the Limitations Act 2002? Well, you get 2 years from discoverability to sue. But then like we all know what like a quagmire discoverability is, right? And when I just said like Limitation Act 2002 has a limitations provision for like the recovery of like loaned funds, when does that 2 years start? Well, that 2 years starts actually like on demand, and when the borrower has failed to pay on that demand, then you get like 2 years. So it's like it's not like necessarily like 2 years from when the loan was made. It's actually like basically 2 years on default, which like if you think about it makes sense, right? Real Property Limitations Act, yes, there is Section 4 and then there's Section 5, because Section 5 like is a deferring provision essentially. So the right of recovery begins at the time of dispossession. So it can actually like really kind of stretch the period. And 5(1)(b) also has an important provision for what happens like on death as like the event of dispossession as well. So I think this decision is a good one. I just think that sometimes like when judges have already like made up their minds on the merits, and they're just, like addressing like this like one other technical argument just to like sort of like give like full reasons to every argument that was put out there. Sometimes like, it not every issue may get its due. And so like not every case is sort of like maybe like the Bible on that issue, so to speak. And Gomes and the Kolnick decision, Trustee Act, or Property Limitations Act, how that like still interacts or like not. All of this is like something that I think people have to intentionally like think about with like every file. Even though like we have as our back pockets like these bright line, like this is where the timing is at, then you can diarize for your files. But still, like every time you really have to think about like the actual issues involved, and like who is actually going to be and who are the like the parties that are involved, right? Because it's not that the Trustee Act always applies just because like there is an estate named in the proceeding, right? Like in that Gomes decision, the estate that was named is actually like not the deceased person who did that transfer to begin with. So like that person at issue was not a party to the proceeding. And so that's why like that decision never talked about the Trustee Act, because it doesn't apply. It does not have to do with like nobody raised any wrongdoing. They did raise the wrongdoing of this like deceased person, but the relief is sought actually against like the title owners of the property, which is why it was actually about the Real Property Limitations Act without ever making reference to the Trustee Act. So, like you have to be really like mindful about how things are pleaded. And at the end of the day, like that is like our job as like lawyers, right? Like if it really is just like everything is so straightforward, then really we don't necessarily need like a judicial system, right? Like then like, like why does someone have to decide this stuff? And again, it's like sort of too bad, like in the case that we are actually talking about, this Klemensiewicz case, because kind of like I said, like, on a documentation level, like other than like actually going to a lawyer and like doing even like an extra layer of documentation, it kind of seems like this applicant, the dad, was gonna like make his lawsuit anyways, right? Like he still did it in the face of that gift letter, and he knew he wasn't on title, he didn't sign that loan agreement. So like, well, what more could have been done? And it's just like sometimes like people just end up in litigation, like even though like really like what else could they have done to prevent it? And then the courts like do have to decide it, but can it always be disposed of by a limitations period? Maybe yes, maybe not. Okay. Any other final comments, Aaron?
I just really quickly, I just wanted to touch on a point you had made earlier about this is such a common scenario that pops up in this kind of a context. There's a quote here from the court, and so the court here says there are conspicuous indications that this application is a last-ditch attempt to alter the legal nature of the 525. Marcel's notice of application and supporting affidavit initially advanced the position that the 525 was his contribution to the purchase of the home. The relief sought was that he be registered as a title holder. Only after it became clear on his cross-examination that Marcel knew from the beginning that he was not entitled, was the original claim abandoned and the current position adopted that the money was a loan. So yeah, I mean, like the court in this case really they went to the heart of what the appellant's claims were. They disposed of it, and they also then dealt with the technical argument about the limitations period.
Yeah, I mean, like, I actually like don't know why the applicant like changed his position the way he did, just because it came out on cross-examination that he always knew he wasn't on title. Because like at the end of the day, like that's the whole point of like the legal principle behind like purchase money resulting trust, is that like you are the person who put up the money to buy the property, but you are not on title, and therefore like the law presumes that beneficial interest in the property is actually like yours, even though it's legally in the name of somebody else. So like, and those are like intentional circumstances, like a lot of the time. Like you may intentionally be a foreign buyer of a condo in Ontario. You put up the money, but you have like your son who is resident in Ontario buy it, and therefore like maybe like you save some like money on like whatever like tax on foreign buyers that like a government may be levying on the day, right? Like, so a lot of times like people do know that, and it is still a viable trust claim. So again, like not totally why the positions would change, but either way, like it just didn't seem like there's anything there. And I am glad that like the gift letter was given effect at the end of the day, honestly, because it just seems like it is straight. It's without more reasons to like doubt the veracity of like the gift letter, or maybe like the reasons why it was signed. You know, sometimes things are just what they are. It is what it is. Okay. So I think that's it for today. Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thank you so much for listening. I'm Doreen So.
And I'm Aaron Chan.
Great. Thanks.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.